God is dawn. Like and subscribe. Comment some night. Love this light. Here's God is dawn. God is dawn. God is dawn. Peace world. Welcome or welcome back. I'm Goddess Dawn, the queen of info. That's right. And I'm back with yet another R. Kelly case update. I told y'all it's heating up as it's the eve of the first trial, the New York federal trial for R. Kelly, where he's facing RICO charges, Mann Act charges. And as the trial nears, the defense attorneys are seemingly trying to stall the proceedings by muddling the pathway, throwing everything they can at the prosecution, who, by the way, have handled the responses like champs. The defense's motions have been less than with regard to the standard. They just don't reach the bar. To say subpar would be putting it lightly. And one of them is rumored to be a part of a defense fund scam, but you didn't hear that from me. Moving on, the judge has ordered in favor of the government in regard to the protective order over the 3,500 materials. Here's what it entails. We're going to read some of it. So you see the order on the screen. And the judge has hereby ordered that, number one, all materials produced by the government to the defendant pursuant to 18 U.S.C. 3500 and the copies thereof shall be returned to the government within 10 days upon conclusion of the trial in the above captioned case. Number two, the defendant and his counsel are prohibited from disclosing or disseminating Section 3500 material to anyone other than the defendant, his counsel who have filed notices of appearance in the above reference case, defense investigators or staff assisting defense counsel. Any such investigators and staff shall be informed of and shall be found by the entirety of this order. Number three, the defendant is prohibited from taking any Section 3500 material labeled protected 3500 material or any paper or electronic copies or summaries of such material into any jail facility other than in the courthouse, or from possessing such material or copies in any such facility except when reviewing the material in the presence of defense counsel or staff assisting such counsel. The defendant may, however, possess in a jail facility compact discs and a single paper copy of the protected 3500 material and may review such material outside the presence of defense counsel or staff assisting such counsel. Protected 3500 material possessed by the defendant in any jail facility printed and is subject to all restrictions set forth above in paragraph 2. Violations of those restrictions will be deemed contempt of court. Now, I've heard a couple of bloggers that support R. Kelly claim that this is a win for the defense, and that's not actually the case. This order is in the name of the protective order and not the motion to compel that the defense filed. Even though they are getting one paper copy for him to review. It's so weird that they're fighting for paper documents for a man who supposedly can't even read. But moving on, the government has filed a response to the defense's motion asking the judge to reconsider her order on the anonymous jury. They're not challenging the partial sequestering, but are asking for access to potential jurors' info, name, workplace, neighborhood, social media. Well, the government has responded, and here's what they have to say. I'm going to just read some parts that I outlined, starting with the first paragraph. The government respectfully submits this letter in response to the defendant, Robert Sylvester Kelly's motion for reconsideration of the court's October 8th, 2020 order granting the government's motion for an anonymous and partially sequestered jury. For the reasons set forth below, the defendant cannot meet the high standard for reconsideration, and his motion should be summarily denied. And they go into the relevant background and talk about how on July 8, 2020, the government filed its motion for an anonymous and partially sequestered jury. Number one, the identities of all prospective jurors, including their names, addresses, and places of employment, not be revealed to either party or their attorneys. Number two, from the time each juror is impaneled until the conclusion of the trial, the jurors eat lunch together and be accompanied in and out of the courthouse by members of the United States Marshal Service each day so that they do not mingle in the courthouse with the public or any other potential trial spectator. On July 29, 2020, the defendant filed his opposition to the motion, in which he argued, number one, there's no reason to believe the jury needs the protection of anonymity, and the anonymous jury would unduly compromise his ability to effectively select a fair and impartial jury. The defendant did not appear to oppose the government's request for a partially sequestered jury. They go on to outline the defense's argument below, and then they go on to talk about their reply to that argument. They say on August 5th, 2020, the government filed a reply memorandum addressing each of the defendant's arguments, including his reliance on Naput Stone and other cases. So the government filed the motion initially. The defense responded. The government replied back, and then the judge ordered in the government's favor. So that's how that went. But here we are, and they're asking for reconsideration. So then the government goes into the legal standard for reconsideration. It's a high standard, and it has strict rules. I'll read a little bit of what they have here. It says, contrary to the defendant's claim that even the jurors' neighborhoods will remain secret, as the government made clear in its reply memorandum, the extensive joint proposed questionnaire will provide the parties with the extensive background information about the prospective jurors, including age, sex, neighborhood of residence, where the jurors were born and raised, and where else they have lived, their employment status and description of their occupation and job duties, education, languages spoken, and family background. They also say that a motion for reconsideration is not a vehicle for litigants to make repetitive arguments that the court has already considered, and it cannot be used to fill in the gaps of a losing argument. Burn. Finally, they say the defendant's motion falls short of meeting the strict standard for a reconsideration. Indeed, it serves as a quintessential example for the type of reconsideration motion that should be summarily rejected, namely a motion that re-argues those issues already considered when a party does not like the way the original motion was resolved. And lastly, the court's voir dire procedures here will result in the parties having far more information regarding potential jurors. So R. Kelly has a status conference on February 9th. I think at that point, they may even determine whether or not they're going to be able to meet deadlines in order to progress with the trial in April. And the jury selection is slated for March. I have all the confidence that the judge will side with the prosecution and keep the anonymous jury, well, anonymous. The bottom line is that the motion was poorly written and poorly argued. These attorneys should be ashamed, and they're clearly out of their league. What do you think? Let me know in the comments. And while you're here, like this video, share, subscribe if you haven't already done so. Oh, and join the channel for exclusive stuff. The link is in the description box of this video. Thank you so much. I truly do appreciate you. Till next time, peace.